We're going to move on to estate of post, which is my favorite type of appellate case, which is one that has been depublished. But I will speak about it just very briefly because I do think it's interesting, and I think I have an inkling as to why it was depublished. In estate of post, the probate court ruled that petitioners were entitled to the proceeds of a life insurance policy as beneficiaries under the estate, even though the objector was the named beneficiary under the policy. And the Court of Appeal reversed, saying that the probate court's jurisdiction did not extend to the life insurance policy because it only has jurisdiction over the assets that are within the estate, and the proceeds of a life insurance policy are not subject to probate. And therefore, the decedent's estate had no interest in the proceeds of the policy, and had the decedent merely designated the beneficiary, then that could have fixed the situation. But obviously, I think this case was depublished because we have, probate code sections like 850, which say that if there's a dispute between, the estate and a third party, and the estate may have a claim, then, that's within the jurisdiction of the probate court. So I suspect that the view in depublishing was that this may not have been correctly decided.
The next case is Black versus Black. How many litigators do we have in the room? I think this is perhaps my favorite case in reading through all the materials that we reviewed in preparation for today. And I don't see any of the participants who are well known to many of us in the case here today, which allows me to say whatever I want. As long as you all promise not to tell them. Black is an interesting case. It's a $65 million trust dispute. And it essentially hinges on the issue of a specific gift versus a residuary gift. And we have a whole slug of petitions. We have a whole slug of objections. We have preliminary settlements, we have subsequent settlements, we have siblings acting as executors, we have institutional trustees being replaced by other institutional trustees. It's the stuff that life is made of. And ultimately, what we get to here is we have one beneficiary, Richard, who is looking to have his cake and eat it too. Files an objection with the court in response to an accounting that's presented. And the result of that objection is that he essentially wants to have his gift determined to be a specific gift so that he can get it in addition to his 35% interest in the trust. More is always more, especially when it comes to beneficiaries. Raise of hands for anybody who disagrees based on your experience with beneficiaries? One, not always. Okay, it's fair. We probably shared that one client. But the result is the trial court kind of gets it a little wrong, and they end up calling it a specific gift, but treating it like a residuary gift, and it goes up on appeal. And what ends up happening on appeal is the appellate court basically says, the trial court called it a specific gift. It's not a specific gift, it's a residuary gift. And as we've summarized in the materials, the court basically says if it's part of what's left over at the end when everything else is given away, it's a residuary gift. And they take what is a very common occurrence, at least based on my experience, where a mother, father, aunt, uncle, grandparents want to give something specifically to a child, grandchild, friend, neighbor, attorney, and don't articulate exactly how they want that to go. And specific gifts end up getting thrown into residuary language. It can create some confusion, especially when you have greedy beneficiaries other than the one that we represented.
Here's another case about a beneficiary besides the one that Scott and gentleman over there represent. This is a classic case of bad beneficiaries make okay law. So Charles de Gama objected to private fiduciary Powell's third accounting on several grounds, many of which in the appellate opinion were expressed as having no support in law or fact, and some of which actually pertain to prior accounting periods or things that even happened before Powell became a trustee. One of the objections was that Powell had failed to file a declaration to support requests for fees under San Diego local rules. We have a similar rule here, as you know. Powell argued that the declaration was not needed because court approval is not required by a statute for a trustee to receive compensation. And the probate court overruled each of Charles's objections, found them to be brought without reasonable cause and bad faith, and ordered Charles to pay Powell's fees from his share of the trust or from his personal funds if not adequate. Charles appealed and the Court of Appeal affirmed. And none of this was particularly surprising. As to the failure to file a declaration, the Court of Appeal said that local rules, it's really up to the court as to whether or not to enforce those, but they can't narrow or conflict with the probate code or other statutory requirements. And to the extent that local rules require more than the statute's content requirements, the local rules may be viewed as optional. That's good to know. I'm sure that you should not view local rules as optional in your own practice, but this is what the Court of Appeal said. On the settlement of an account, allowance of compensation rests within the sound discretion of the court, and it's only a substantial evidence standard, which I don't think is groundbreaking. What was interesting was the court's order that not only would Charles's interest in the trust be charged, but that he could actually be required to pay additional fees out of his own personal funds, which does at first blush seem to conflict with a case we talked about a couple years ago, which is the Pizarro case, which says that in a fee award against a beneficiary, when you're charging their interest, you can't reach beyond the assets of the trust. I think the distinction is in Pizarro, because I went back and read it, in Pizarro, that was an equitable decision, not based on a statutory remedy. Here, the fee award was based on 17-211, which specifically allows for a beneficiary to have to pay attorney's fees back for unreasonable bad faith objection. And so I think if you're seeking to seek that remedy against a beneficiary on an accounting proceeding, make sure you're seeking the statutory remedy rather than simply the common law remedy under, say, estate of Ivy.
The next case is Estate of O'Connor. This is a case discussing the requirements to exercise a power of appointment. And the question was whether the decedent had adequately and specifically exercised his power of appointment, not only in accord with the documents, which is what's required, but consistently with California statute, specifically Probate Code Section 632. The language that the decedent had utilized in his will stated that I exercise any power of appointment which I may have over that portion of the trust or trusts established by my parents for my benefit or any other trusts for which I have a power of appointment. And that kind of blanket, anything I have, anything in the world that I really don't know anything about, has been argued to be insufficiently specific and adequate to constitute an exercise of the power of appointment. And here, the appellate court held that that language was specific enough. It did satisfy both the statutory and the trust written requirements because it did identify the fact that there were trusts, that it was his parents' trusts. And the court really spent a significant amount of time looking at what we all know is the gravamen of all of these cases, which is what was the testator's intent. All right, so the court spent time talking about examining the issue of what was his intent, what was the evidence of intent, and more specifically, was there any evidence of any contrary intent, of which there was none. And the court said that the record was clear and clean, that this is what was intended. And as such, the court made its ruling.